I never thought a metal tank in my backyard would cost me my job, my reputation, and nearly my freedom. But that was before Brenda Connolly decided it was her personal mission to destroy my life. My name is Zachary Lawson, and I moved to Meadowbrook Village in Boulder, Colorado 3 years ago after my divorce. The place seemed perfect at first. A quiet suburban development with decent houses, mountain views, and people who mostly kept to themselves. I worked as a mechanical contractor, specializing in HVAC systems, and I had saved enough to buy a modest 3-bedroom house with a nice yard. The HOA seemed reasonable during the initial meetings. Monthly dues were fair, the rules seemed standard, and the community center looked well maintained. Everything changed last October when I decided to install a 500-gallon propane tank in my backyard. My house ran on natural gas, but I had invested in a backup generator system after the previous winter when power outages left me freezing for 3 days straight. The generator needed propane to run, and I wanted enough capacity to last through extended outages. I contacted a reputable propane company, got all the necessary permits from Boulder County, and had professionals install the tank according to every safety code imaginable. The tank sat behind my fence, barely visible from the street, painted a neutral beige color that blended with my fence. 2 days after installation, I found a bright orange notice taped to my front door. Violation of HOA Covenant Section 4.7, exterior modifications without approval. You have 72 hours to respond. I stared at the notice, confused. The propane tank was behind my fence on my property and fully permitted by the county. I had read through the HOA documents when I bought the house, and while exterior modifications needed approval, utility installations were specifically exempt. I had even double-checked with my real estate attorney before proceeding. I called the HOA office and got their answering machine. Professional, polite, asking me to leave a message. I explained the situation and requested a meeting to discuss the notice. Brenda Connolly called me back within an hour. Mr. Lawson, this is Brenda Connolly, president of the Meadowbrook Village HOA Board. We received your message regarding the violation notice. Her voice had that particular quality I had learned to recognize over the years, sweet on the surface, but with an edge underneath that suggested she was already irritated before the conversation even started. Hi, Miss Connolly. I think there might be some confusion. The propane tank I installed is a utility installation, which according to Section 4.7 subsection B is exempt from the architectural review process. Mr. Lawson, I have been president of this HOA for 7 years. I am quite familiar with our covenants. The tank is visible from neighboring properties and constitutes an eyesore. It requires approval, which you did not obtain. The tank is behind my fence and barely visible. I also have all the county permits showing it meets every safety standard. County permits are irrelevant to HOA regulations. You need to submit an architectural review request immediately or face daily fines of $100 until compliance is achieved. $100 per day. I felt my jaw tighten. I would like to attend the next board meeting to discuss this. The next meeting is in 3 weeks. Your fines will begin accruing in 72 hours unless you remove the tank or submit the architectural review. Then, I will submit the architectural review. The review process takes up to 60 days. Fines will continue until approval is granted. This was a trap. They would fine me thousands of dollars while dragging out the approval process, then likely deny it anyway. Miss Connolly, with respect, this seems unreasonable. The tank is necessary for my backup power system, it is legal, and it is barely visible. Mr. Lawson, rules exist for a reason. If we let one homeowner do whatever they want, chaos ensues. I suggest you remove the tank and find an alternative solution." She hung up before I could respond. I spent the next 2 days researching HOA law in Colorado and consulting with my attorney, Marcus Chen. Marcus had helped me with my house purchase and knew the HOA documents well. "Zachary, technically they are right that you need architectural approval, but the exemption for utilities is clearly stated. The problem is enforcing your rights will require either mediation or litigation, both of which take time. They can fine you during that process. So they can just ignore their own rules. Unfortunately, HOA boards often abuse their authority. The law provides remedies, but those remedies are not immediate. My advice is to submit the architectural review, document everything, and be prepared to fight this if they deny it." I submitted the architectural review the next day, including photographs showing how minimal the visual impact was, copies of all permits and safety certifications, and a detailed explanation of why the tank was necessary. I hand-delivered the application to the HOA office in the community center. The community center was the crown jewel of Meadowbrook Village, a large building with a gym, meeting rooms, a kitchen, and a swimming pool. The HOA board offices were on the second floor. I had only been inside a few times, mostly for mandatory annual meetings. Brenda Connolly was there when I arrived, reviewing paperwork at the reception desk. She was exactly what I expected. Mid-50s, bleached blonde hair cut in that specific suburban mom style, expensive yoga clothes despite no evidence she had ever done yoga, and an expression of permanent disapproval. "Mr. Lawson, I assume you are here to submit your architectural review." "Yes, everything is here." I handed her the folder, which I had carefully organized with tabs and a detailed table of contents. She flipped through it for about 10 seconds, barely glancing at the contents. "This will be reviewed at the next board meeting. Fines will begin accruing tomorrow as you missed the 72-hour deadline." I submitted this within the deadline. Today is the third day. The deadline was 3 business days. Today does not count as you submitted after noon. I had specifically delivered it at 10 in the morning. The clock on the wall behind her showed 10:27 a.m. "Miss Connolly, it is currently 10:27 in the morning." She did not even glance at the clock. "Our office hours begin at noon on Wednesdays. This will be recorded as received tomorrow." I realized then that facts and logic did not matter to Brenda Connolly. This was about power and control. She had decided I needed to be punished for some perceived slight, and she would twist any rule necessary to accomplish that goal. "I would like a receipt showing I delivered this today, with the time stamp." We do not provide receipts for architectural reviews. I pulled out my phone and took a photograph of her holding my folder, with the clock visible in the background. "What do you think you are doing?" Her voice rose sharply, documenting my submission for my attorney, her face flushed red. "You are not allowed to photograph inside HOA offices without permission." I was not aware of that rule. Where is it documented? It is common sense. Privacy concerns. "I could call the police right now for what you just did." I was done playing games. "Please do. I would love to explain to them how you are attempting to impose thousands of dollars in fines based on false documentation." She glared at me with pure hatred. "Get out, now, or I will have you trespassed from community property." I left, but I emailed the photo to Marcus immediately along with a detailed description of the conversation. He responded within minutes that we now had documentation of bad faith conduct, which would be useful if this went to court. The fines started appearing in my HOA account the next day, $100 per day. After a week, I received a formal notice that I owed $700, payable immediately, with interest accruing at 18% annually on any unpaid balance. I did not pay. Instead, Marcus sent a formal letter to the HOA board citing the specific covenant exemptions and demanding they halt all fines and approve the propane tank installation. The letter was professional but firm, making it clear we were prepared to litigate if necessary. The HOA responded by increasing my fines to $200 per day for continued willful violation. The next board meeting was on a Tuesday evening. I arrived 30 minutes early with Marcus. About 40 other homeowners were there, most looking bored or irritated to be attending. These meetings were mandatory once per year for voting purposes, but this was a regular monthly meeting, so attendance was sparse. Brenda Connolly sat at a table at the front with 4 other board members. I recognized 2 of them. Dale Morrison, a retired accountant who always looked like he wished he was anywhere else, and Patricia Fuentes, who ran a yoga studio downtown and seemed to genuinely care about the community. The other 2 were strangers to me. Brenda called the meeting to order with a sharp rap of her gavel. She went through standard business quickly: budget reports, landscaping contracts, pool maintenance schedules. Then she reached new business. Item 7. Architectural review request from Zachary Lawson regarding installation of an unapproved propane storage tank. I stood up. I would like to address the board regarding my application. Sit down, Mr. Lawson. We will review your application and notify you of our decision. Marcus stood beside me. Miss Connolly, Mr. Lawson has the right to present his case under Colorado HOA law. Architectural review hearings require the homeowner be given an opportunity to speak. Brenda's jaw tightened. Are you a lawyer, sir? Yes, I am Marcus Chen, representing Mr. Lawson in this matter. This is a board meeting, not a courtroom. Lawyers are not necessary. Mr. Lawson has the right to representation if he chooses. That is also Colorado law. Dale Morrison leaned forward, looking uncomfortable. Brenda, maybe we should just let him talk. Get this over with. Brenda shot him a look that could have melted steel, but she gestured sharply at me. Fine. You have 3 minutes. I walked to the front and distributed copies of my application to each board member. Then I explained the situation clearly and calmly. The propane tank was legal, permitted, necessary for emergency power, barely visible, and specifically exempt under the utility installation provision of the covenants. I showed photographs demonstrating the minimal visual impact. I showed the safety certifications and professional installation documentation. When I finished, Patricia Fuentes nodded thoughtfully. This actually seems very reasonable. I can barely see the tank in these photos, and if it is for emergency backup power, that benefits everyone. Brenda cut her off. Patricia, the issue is not whether we personally find it reasonable. The issue is maintaining architectural consistency throughout the community. If we allow Mr. Lawson to install whatever he wants, what stops everyone else from doing the same? But the covenants specifically exempt utility installations, Patricia said, flipping through the pages. That exemption applies to installations by utility companies. Gas lines, electrical connections, that sort of thing. Not personal storage tanks. Marcus stood again. That interpretation is incorrect. The language clearly states utility installations broadly, without limiting it to utility company work. Mr. Lawson's propane system is a utility installation by any reasonable definition. That is your opinion, Mr. Chen. The board has the authority to interpret our own covenants. Actually, when covenant language is ambiguous, Colorado law requires interpretation in favor of the homeowner, not the HOA. Brenda stood up abruptly. The board will take this under advisement and issue a written decision within 30 days. This discussion is closed." She moved to the next agenda item before anyone could object. Marcus and I returned to our seats. Patricia Fuentes looked troubled, but she did not push back. Dale Morrison looked like he wanted to be anywhere else. The other two board members had not said a word. After the meeting, Patricia approached me quietly. "Mr. Lawson, I want you to know I think your installation is fine. I am going to vote to approve it. Thank you. I appreciate that." She glanced around, then lowered her voice. "Brenda has been getting worse over the past year, more controlling, more aggressive. Several of us have tried to moderate her behavior, but she has a majority on most issues. I am sorry you are dealing with this. Is there any way to remove her as president?" "Only through a vote at the annual meeting, which is not until March. You would need to get enough homeowners to attend and vote her out, which is difficult. Most people do not pay attention to HOA politics until it affects them personally." She left before anyone noticed our conversation. Marcus and I walked to the parking lot together. "What are our options?" I asked. "We wait for their decision. When they deny your application, which they will, we file for mediation. If mediation fails, we file a lawsuit seeking declaratory judgment that your installation is permitted under the covenants, plus recovery of attorney fees and damages for the improper fines." "How long will that take?" "Mediation usually takes 2 to 3 months to schedule. If it fails, litigation can take a year or more. During that time, they can continue fining you, though if we ultimately win, they will have to refund everything with interest. So I am looking at potentially tens of thousands of dollars in fines that I will not get back for over a year, assuming I win." "Correct. And there is always a risk we lose. Courts give HOA boards significant deference in interpretation of their own rules." I drove home feeling defeated. The system was rigged in favor of HOAs abusing their authority. They could impose massive fines with no immediate oversight, forcing homeowners to either comply or spend years fighting in court with no guarantee of success. The fines continued accumulating. $200 per day. After a month, I owed over $6,000. The HOA sent increasingly aggressive collection letters, threatening liens on my property if I did not pay immediately. Then, I got the formal denial of my architectural review. The letter was 3 pages of bureaucratic nonsense, but the core reasoning was exactly what Brenda had stated in the meeting. The board had interpreted the utility exemption to apply only to utility company installations, not personal propane tanks. The tank was deemed an eyesore that negatively impacted property values and community aesthetics. My application was denied, and I had 30 days to remove the tank or face escalating fines and potential legal action, including foreclosure. Marcus immediately filed for mediation. The mediation was scheduled for January 15th, nearly 3 months away. In the meantime, the HOA increased my fines to $300 per day for continued defiance of a final board decision. $300 per day meant $9,000 per month. I could not afford that. My savings would be depleted in a few months, and the HOA could then place a lien on my house and eventually foreclose. People actually lost their homes over HOA disputes like this. I needed leverage, and I needed it fast. The community center became the focus of my attention. Not for any nefarious reason initially, just professional curiosity. I was an HVAC contractor. I noticed things about heating and cooling systems that normal people did not, and I had noticed something odd about the community center's heating system. It ran on propane. The community center was built in 2008, before natural gas lines reached this part of Boulder County. The original developers had installed a large propane system to heat the building, and they had never bothered to convert it to natural gas, even after the lines were extended in 2012. A huge 10,000-gallon propane tank sat behind the community center, surrounded by a decorative fence. More importantly, the propane contract was handled through an outside company. I knew this because I had actually bid on the HVAC maintenance contract for the community center 2 years ago. I had reviewed all their systems during the bidding process. The propane was supplied by Mountain View Propane, a regional company that had an exclusive contract with the HOA. I called Mountain View Propane and asked to speak to their contracts manager. After being transferred twice, I reached a helpful woman named Sandra. "Hi, I am calling about the propane contract for Meadowbrook Village HOA Community Center. Can you tell me who signs off on that contract? Let me pull up the account." Okay, the contract is signed annually by the HOA board president. Currently, that is a Brenda Connolly. Is there an issue with the account? No issue, just gathering information. Thank you. I hung up and did more research. The propane contract was a service agreement where Mountain View Propane maintained the tank, delivered propane as needed, and handled all safety inspections. The contract was between Mountain View Propane and the HOA, not the community center building itself. Here is where things got interesting. I had been doing research on HOA governance, and I discovered something fascinating. The community center building was actually owned collectively by all the homeowners, not by the HOA board. The HOA board managed the property, but they did not own it. Every homeowner had an undivided interest in the common property proportional to their property value assessment. I owned approximately 0.3% of the community center, based on my property's assessed value versus the total community property values. Colorado law has specific provisions about shared property ownership. Any co-owner of a property has certain rights regarding that property, including the right to access utility services for that property. I called Marcus with my idea. "Marcus, can the HOA legally prevent me from accessing utility services for property I partially own?" "What are you thinking, Zachary?" I explained my research. The community center ran on propane. I was a co-owner of that property. The HOA was currently preventing me from using propane on my own property, while simultaneously using propane on our shared property. That is a creative argument, but I am not sure where you are going with it. What if I canceled the propane service to the community center? There was a long silence on the phone. "Zachary, that would be a very aggressive move, probably illegal. You cannot just unilaterally cancel a contract the HOA has signed. But if I have an ownership interest in the property, do I not have some say in the utility services used for that property?" "Theoretically, but that authority is delegated to the HOA board for management purposes. You would need to challenge that authority through proper channels, not just take independent action." "What if the propane company agreed to work with me? Why would they do that?" "Because I can offer them more business. I am a licensed contractor. I have been building relationships with propane suppliers for my business. If I could offer Mountain View Propane additional contracts for other properties I work on, they might be willing to renegotiate the HOA contract to something more favorable." This was true. I had recently landed contracts for HVAC work on 3 commercial properties that needed propane services. That was potentially significant business for a regional propane company. That is legal, but it is not going to help you shut off heat to the community center. Just hear me out. What if during the contract renegotiation, there was a brief lapse in service? Not because I maliciously shut anything off, but because the old contract expired and the new contract had not been finalized yet. Zachary, that is playing with fire. If people freeze because you caused a gap in propane service, you could face serious legal consequences. The community center is not residential. It is a recreational facility. If it is cold for a few days, nobody is in danger. It would be inconvenient but not dangerous. And you think this would give you leverage to get them to back off your propane tank. I think it would demonstrate that their position on propane is hypocritical and arbitrary. They are happy to use propane when it benefits them, but they want to fine me thousands of dollars for doing the same thing on my own property. Marcus was quiet for a long moment. I cannot advise you to do this. It is ethically questionable and potentially illegal. But I also understand you are being backed into a corner by an abusive HOA board. If you proceed, document everything meticulously and make sure any service interruption is genuinely due to contract issues, not intentional sabotage. I spent the next week reaching out to Mountain View Propane. I spoke to Sandra again, then her manager, then finally the regional vice president, a guy named Tom Brennan. Mr. Lawson, Sandra mentioned you called about the Meadowbrook Village account. What is your interest in that? I am a homeowner in Meadowbrook Village and also a licensed mechanical contractor. I have been reviewing our HOA expenses and noticed the propane contract seems expensive compared to market rates. I also have several commercial properties I am working with that need propane services, and I wanted to discuss possibly bundling those contracts with a renegotiated HOA contract. Interesting. What kind of commercial properties? I described the 3 properties. A restaurant, a small hotel, and an office building. All needed propane for heating and hot water. Combined, they represented about 3 times the usage volume of the Meadowbrook Village Community Center. That is substantial business. What kind of rates were you looking for? I would need competitive rates for my commercial clients, and I think the HOA contract could be renegotiated at a lower rate as well. But there is a complication. What kind of complication? I am currently in a dispute with the HOA board. They are fining me for installing a propane tank on my property while simultaneously using propane for the community center. It is a long story, but the point is, I want to make sure any new contract reflects fair treatment for all propane users in the community. Tom was quiet for a moment. Mr. Lawson, are you trying to use contract negotiations as leverage in an HOA dispute? I am trying to ensure that HOA decisions about propane usage are made fairly and consistently. If the board is going to take a hardline stance against propane on residential properties, that should inform whether propane is appropriate for community facilities as well. That sounds like an internal HOA matter that we should stay out of. Normally, I would agree, but your company has a contract with the HOA that comes up for renewal in March. I am a partial owner of the property your company services. I think I have standing to participate in discussions about whether that contract should be renewed and under what terms. Do you have authority to negotiate on behalf of the HOA? I have authority to raise concerns as a homeowner and property co-owner. I also have the ability to offer you significant new business if you are willing to work with me on fair contract terms. Tom thought about it. Let me review the current contract and discuss this with our legal team. I will get back to you. He called me back 3 days later. Mr. Lawson, I have reviewed the Meadowbrook Village contract. It actually expires on December 31st, which is in about 2 weeks. The contract has an automatic renewal clause unless either party provides 30 days notice of termination. My heart rate picked up. So, if you provided notice now, the contract would end on December 31st, correct? However, we have had a good relationship with Meadowbrook Village for years. I would not terminate without cause. What if I could guarantee you the 3 commercial contracts I mentioned, with better overall revenue than the Meadowbrook Village contract, in exchange for allowing the HOA contract to lapse temporarily while they reconsider their propane policies? How temporarily? Just until they approve my architectural review for my propane tank. Once they do that, you could negotiate a new contract with them on better terms than before. Mr. Lawson, you are asking me to cut off heat to a community center in the middle of winter to pressure an HOA board. That is not a position I am comfortable with. I am asking you to make a business decision not to renew a contract with a client that has been applying arbitrary and discriminatory standards about propane usage. I am offering you replacement business that is more lucrative. The fact that the HOA might feel pressure to reconsider their policies is a side effect, not the primary goal. That was complete nonsense, and we both knew it, but it gave Tom plausible deniability. If we did not renew, the HOA could just contract with another propane company. They could, but that would take time. New contracts require board approval, vendor vetting, installation coordination. It would be at least a few weeks, possibly longer. During that time, they would be motivated to resolve disputes and reconsider policies. I need to think about this. Tom, I am being fined $300 per day by this HOA for using propane while they use propane themselves. I am facing potential foreclosure over a legal, safe, properly permitted utility installation. I am not asking you to do anything illegal or dangerous. I am asking you to make a business decision not to continue a relationship with a client that treats people unfairly. Send me the details on those commercial contracts. I will review and let you know. I sent him comprehensive proposals for all 3 properties. The numbers were real. I had already negotiated agreements with the property owners that were contingent on propane pricing. If Tom could offer competitive rates, all 3 would sign immediately. He called me back on December 20th. Mr. Lawson, I have reviewed your proposals. Those are solid contracts. If you can deliver all 3, we are willing to let the Meadowbrook Village contract lapse without renewal. Our position will be that we are restructuring our contract portfolio and cannot accommodate the HOA's needs at this time. We will provide them with referrals to other propane companies. When will you notify them? Today. The contract requires 30 days' notice, but since it expires in 11 days, we will inform them immediately that we will not be renewing and they need to make alternative arrangements. Thank you, Tom. Mr. Lawson, I hope you know what you are doing. This is going to create significant problems for a lot of people. Those problems are created by an HOA board that has decided to abuse their authority. I am just removing their ability to be hypocrites about propane. I felt a mix of excitement and anxiety after the call. This was a dramatic escalation, but I was out of options. The mediation was not scheduled until January 15th. By then, I would owe over $25,000 in fines. The HOA would have a lien on my property, and I would be facing potential foreclosure. I needed to change the dynamic immediately. Mountain View Propane sent their termination notice to the HOA that afternoon. I know because Brenda Connolly called me at 6:47 p.m., screaming into the phone. What did you do? What the hell did you do? I am sorry, miss. Connolly, I do not know what you are referring to. Our propane company just canceled our contract. We have no heat for the community center. Did you have something to do with this? Why would I have anything to do with your propane contract? Do not play games with me. This is your revenge for the fines. Miss Connolly, I have no control over who your propane company chooses to do business with. If they terminated your contract, that is between you and them. You are going to fix this, right now. I am not sure how I would fix a contract termination. Have you tried calling other propane companies? It is 10 days before Christmas. Every company is booked solid. We have events scheduled in the community center all week. That sounds like a difficult situation. Perhaps the board should consider whether your aggressive stance on propane usage has been wise, given that you rely on propane yourselves. There was a long silence. When she spoke again, her voice was cold and controlled. If you think this is going to make us back down, you are wrong. We are going to bury you. You are going to lose your house, your business, everything. I will make sure of it. She hung up. I sat in my kitchen, hands shaking slightly. I had just declared war on my HOA and there was no going back now. The next few days were chaos. The community center had enough propane in the tank to last about a week with normal usage. The HOA desperately contacted other propane companies, but everyone was either fully booked for the holidays or quoted premium rush rates. The few companies that could provide immediate service wanted to charge triple the normal rates for emergency holiday service. The HOA board held an emergency meeting on December 22nd. I attended with Marcus. The room was packed with angry homeowners who had events scheduled at the community center over the holidays. Christmas parties, family gatherings, youth group meetings. Brenda Connolly looked like she had not slept in days. She called the meeting to order and explained the situation. Their propane company had unexpectedly terminated their contract, and they were working to secure alternative services. A homeowner in the back raised his hand. Why did they terminate? We have used them for years. They indicated they were restructuring their contract portfolio. It was an unexpected business decision. That is convenient timing given the dispute with Zachary Lawson. Brenda's face went red. If you are implying that Mr. Lawson had something to do with this, we have no evidence of that. But you suspect it. What I suspect is irrelevant. We are dealing with the situation as it exists. Another homeowner spoke up. How much will it cost to get emergency service? The quotes we have received range from $12,000 to $20,000 for immediate service. The room erupted in angry voices. That was an enormous expense for a single month of propane. Patricia Fuentes raised her hand. Brenda, have we considered that maybe this situation is an opportunity to reconsider our position on Mr. Lawson's propane tank? If we are facing enormous costs because of propane supply issues, perhaps forcing him to remove his tank is not the best use of our resources. Absolutely not. If we give in to this kind of manipulation, we set a precedent that homeowners can bully the board into abandoning our rules. But our rules specifically allow utility installations. Multiple people have pointed this out. Patricia, we have been through this. The board has interpreted the covenants, and that interpretation is final, unless it is challenged successfully in mediation or court, which I think is likely. Dale Morrison, the retired accountant, cleared his throat. Brenda, I have been reviewing the numbers. We have already fined Mr. Lawson over $20,000. If he wins in mediation or court, we will have to refund all of that plus his attorney fees, plus potentially pay damages. Combined with this emergency propane expense, we are looking at financial exposure of $50,000 or more. That is a significant hit to our reserves. We have sufficient reserves to handle this. Actually, we do not. Our reserves are at $80,000. We are required to maintain minimum reserves of $60,000. If we spend $20,000 on emergency propane and potentially lose $50,000 in the Lawson case, we would be below minimum reserves and legally required to issue a special assessment to all homeowners. The room got very quiet. Special assessments were the nightmare scenario for HOAs. It meant every homeowner would receive a bill for potentially hundreds or thousands of dollars to cover unexpected expenses. A woman in the front row stood up. "You are saying we might all have to pay money because the board is having a pissing contest with one homeowner over a propane tank that should have been approved in the first place." "It is not a pissing contest," Brenda snapped. "It is about maintaining standards and following proper procedures." "The proper procedure is to follow your own covenants, which apparently you are not doing." The meeting dissolved into arguments. Homeowners yelling at the board trying to maintain control, Marcus sitting quietly next to me taking notes. Finally, Brenda slammed her gavel repeatedly until people quieted down. "We will take a brief recess and reconvene in 15 minutes. During the recess, several homeowners approached me. Some were angry, accusing me of causing this problem. Others were sympathetic, saying the board had been overreaching for years and needed to be checked. Patricia Fuentes pulled me aside. "Mr. Lawson, did you have something to do with the propane contract termination?" I considered lying, but Patricia seemed genuine. "I made a business arrangement that resulted in the propane company choosing not to renew the HOA's contract. I did not break any laws or do anything unethical. I simply offered them better business elsewhere." She nodded slowly. "You are playing a dangerous game. Brenda is vindictive. She will not forget this. She has already been vindictive. I am just defending myself." "I understand. For what it is worth, I am going to propose at the next board meeting that we approve your propane tank and rescind all fines. I think I can get Dale to support it, which would give us a majority." "Thank you. I appreciate that." The meeting reconvened. Brenda announced that the board had decided to contract with Summit Propane for emergency service at a cost of $18,000. Several homeowners groaned. Then Brenda turned her attention to me. "The board has also decided to pursue legal action against Mr. Zachary Lawson for tortious interference with our propane contract. We believe he intentionally caused the termination of our service, which has resulted in substantial damages to the HOA." Marcus stood immediately. "That is a baseless accusation. Mr. Lawson has no control over business decisions made by private companies. If Mountain View Propane chose not to renew your contract, that is their right and their decision. We will let a court decide that. We are also moving forward with foreclosure proceedings on Mr. Lawson's property due to unpaid fines exceeding $20,000. Miss Connolly, you are aware that we have mediation scheduled for January 15th. Initiating foreclosure proceedings before mediation is completed is arguably a violation of Colorado HOA law and could expose the board to additional liability. The mediation is for the architectural review. The fines are a separate matter. The fines are directly tied to the architectural review. They are not separate matters." This was getting ugly fast. I stood up next to Marcus. "Miss Connolly, I would like to make a proposal. I will help coordinate propane service for the community center at reasonable rates through my business contacts. In exchange, the board approves my architectural review and rescinds all fines." "Absolutely not. We do not negotiate with extortionists. I am not extorting anyone. I am offering to help solve a problem while also resolving our dispute." "Your proposal is rejected. This meeting is adjourned." She slammed the gavel and walked out. The other board members followed, except Patricia, who lingered behind looking troubled. The community center ran out of propane on December 27th. Summit Propane was scheduled to deliver on December 30th, but a snowstorm delayed them until January 2nd. The community center was without heat for 6 days during a cold snap that saw temperatures drop below zero. The HOA had to cancel all scheduled events. Angry homeowners flooded the HOA office with complaints. Several families had hosted holiday gatherings that had to be moved or canceled. A youth basketball league had to find alternative facilities. The swimming pool closed because the building was too cold. On January 3rd, I received a formal notice that the HOA was filing a lawsuit against me for tortious interference, seeking damages of $50,000. I also received a notice of lien on my property for unpaid fines, now totaling $27,000. Marcus filed counterclaims for violations of the HOA covenants, bad faith enforcement, and seeking declaratory judgment that my propane tank installation was permitted. He also filed a motion to stay all fines pending resolution of the underlying dispute. The mediation on January 15th was a disaster. The mediator was a retired judge named Harold Kemper. He spent the morning reviewing all the documents and listening to both sides present their cases. Brenda Connolly insisted that I was a rogue homeowner who had violated clear rules, refused to comply with legitimate fines, and then sabotaged the community center's heating system in retaliation. She demanded I remove my propane tank, pay all fines in full, pay for the emergency propane costs at the community center, and agree not to sue the HOA. I presented my case. The propane tank was clearly permitted under the covenant exemptions. The fines were imposed in bad faith. The community center heating issue was not my fault, as I had no control over business decisions by propane companies. Judge Kemper asked Brenda directly about the covenant language exempting utility installations. Miss Connolly, the language here seems quite broad. It states utility installations are exempt from architectural review. Why does that not apply to Mr. Lawson's propane system? Because propane tanks are unsightly and detract from property values. The exemption was intended for things like gas meters and electrical boxes, not large storage tanks. But the language does not specify size limits or distinguish between different types of utility installations. The intent was clear when the covenants were written. Were you involved in writing the original covenants? No, they were written in 2006 when the development was created. So you are inferring intent from a document written nearly 20 years ago by people who are no longer involved. I am interpreting the covenants based on common sense and years of experience managing this community. Judge Kemper turned to me. Mr. Lawson, did you have any involvement in the termination of the HOA's propane contract? This was the critical moment. I could lie, but I was under oath in mediation. Lying could destroy my case and possibly result in perjury charges. Yes, Your Honor, I offered alternative business to the propane company in exchange for them choosing not to renew the HOA contract. Brenda actually gasped. He admits it. He deliberately sabotaged our heating. Miss Connolly, please, Judge Kemper said calmly. He turned back to me. Can you explain your reasoning? The HOA was fining me $300 per day for using propane on my property while simultaneously relying on propane for the community center. I found that hypocritical and discriminatory. I used my business relationships to offer the propane company better contracts elsewhere, which gave them a legitimate business reason to end their relationship with the HOA. I did not break any laws. I did not sabotage anything. I simply competed for the propane company's business and won. That is tortious interference, Brenda shouted. Marcus responded calmly. Tortious interference requires improper means or wrongful conduct. Offering a company better business terms is neither improper nor wrongful. That is how free markets work. Judge Kemper leaned back in his chair. This is a very unusual situation. I am going to be blunt with both of you. Miss Connolly, I think your interpretation of the covenants is strained at best. The language clearly exempts utility installations, and Mr. Lawson's propane system is arguably a utility. Your refusal to approve it appears arbitrary, especially given that the HOA itself uses propane. Brenda started to object, but he held up his hand. However, Mr. Lawson, your conduct in interfering with the community center's propane supply, while perhaps not illegal, was certainly aggressive and has caused real harm to your neighbors who had events canceled. I am sympathetic to your position, but I am troubled by your methods. He paused, looking at both of us. Here is my recommendation. The HOA should immediately approve Mr. Lawson's architectural review and rescind all fines. Mr. Lawson should help coordinate propane service for the community center at reasonable rates and agree not to pursue damages for the improper fines. Both parties should agree to drop all pending litigation. This dispute ends today and everyone moves forward. I looked at Marcus. He nodded slightly. It was not everything I wanted, but it was a reasonable resolution. Brenda Connolly shook her head. Unacceptable. He needs to be held accountable for what he did. Miss Connolly, if this goes to court, you will likely lose on the covenant interpretation. You will have to refund all fines plus his attorney fees and possibly pay damages. Combined with your litigation costs, you are looking at significant financial exposure. This resolution protects the HOA from that risk. I do not care. This is about principle. Patricia Fuentes, who had been sitting silently next to Brenda, finally spoke up. Brenda, I think we should accept the judge's recommendation. This has gone on long enough. You do not have authority to make that decision. Actually, I do. The board voted to authorize you to negotiate in mediation, but any settlement requires majority board approval. I am calling for a vote right now. You cannot call a vote. We are in mediation, not a board meeting. We have 4 board members present. That is a quorum. I am allowed to call for a vote on urgent matters. I move that we accept Judge Kemper's recommendation. Dale Morrison immediately said, I second the motion. Brenda looked furious, but she was trapped. Patricia called for a vote. She, Dale, and 1 other board member voted yes. Brenda and the remaining board member voted no. The motion passed 3-2. Fine, Brenda said through clenched teeth. But I want it on record that I oppose this capitulation. Judge Kemper drafted a settlement agreement on the spot. The HOA approved my architectural review, rescinded all fines, and dropped their lawsuit. I agreed to help coordinate propane service for the community center and drop my counterclaims. All parties released each other from liability. We signed the agreement. It was over. Except it was not over, because Brenda Connolly could not let it go. 2 weeks after the mediation, I received a notice that the HOA was conducting an inspection of my property for code violations. This was allowed under the covenants, but inspections were normally done annually with advance notice. This was a special targeted inspection with only 48 hours notice. The inspector was a man named Craig Helms who ran a local property management company that contracted with various HOAs. He showed up with a clipboard and camera and spent 2 hours examining every inch of my property. He found violations, minor ones. My fence was 4 inches taller than the maximum allowed height due to settling of the ground. My mailbox post was slightly faded and needed repainting. A decorative rock border around my garden extended 6 inches onto the common area grass. A tree branch hung over my neighbor's property line by approximately 3 feet. Each violation came with a fine. $200 for the fence, $100 for the mailbox, $100 for the rock border, $300 for the tree. I had 30 days to correct each violation or face daily fines of $50 per violation. It was petty harassment, but it was technically within the HOA's authority. I corrected all the violations immediately, taking photos before and after to document compliance. I submitted the documentation to the HOA office within a week. 2 days later, I received another notice. The corrections were rejected. The fence, while now the correct height, was not the approved color. The mailbox post was painted but needed to be a specific shade documented in the architectural guidelines. The rock border had been removed but had left an uneven line in the grass. The tree branch had been trimmed but not at the correct angle per arborist standards. This was insane. Marcus sent a letter to the HOA accusing them of harassment and bad faith enforcement in violation of our settlement agreement. The HOA responded that the settlement only covered the propane tank issue, and they had every right to enforce other covenant provisions. I was done playing nice. I called Tom Brennan at Mountain View Propane. Tom, how is the HOA's propane service going? Fine. They are working with Summit Propane now. Why? Summit Propane's contract with them is month to month, right? I believe so. Most emergency contracts are short-term until a longer agreement can be negotiated. If Summit decided not to continue service, would Mountain View be interested in resuming the contract? Possibly. We did not enjoy ending that relationship. It was good, steady business. What if I told you that the HOA is currently in breach of their settlement agreement with me and engaging in continued harassment? Would that change your willingness to work with them? Zachary, I am not getting involved in HOA politics again. The last time was complicated enough. I am not asking you to get involved. I am asking if you would be willing to resume service if they came to you willing to negotiate fairly. If they reached out and offered reasonable terms, we would consider it. Good to know. I called several other propane companies in the region. I explained that I was a contractor with multiple commercial clients needing propane services, which was true, and asked about their capacity. Most were operating near capacity and not looking for new residential HOA contracts, which were lower margin than commercial work. Then I reached out to Summit Propane. I spoke to their operations manager, a woman named Lisa Gentry. Miss Gentry, I am calling about your contract with Meadowbrook Village HOA. I am a homeowner there and wanted to ask about long-term service reliability. Is there a concern? Not with your company's service, which has been fine. More concern about whether the HOA is a good client to work with long-term. They have a history of difficult management and arbitrary enforcement of rules. I wanted to make sure you were aware of that before committing to a long-term contract. We are currently on a month-to-month arrangement while we evaluate whether a longer contract makes sense. That is probably wise. I would hate to see a good company like yours get caught up in the HOA's dysfunction. Can I ask your interest in this? I am the homeowner they were fining $300 per day over a propane tank while they used propane themselves. It was a whole thing. We settled, but they are now harassing me with petty violations in retaliation. I would not want your company to become another target of their vindictive management. Lisa was quiet for a moment. That does sound concerning. I appreciate you bringing it to my attention. We will factor that into our contract discussions. Thank you. Just trying to look out for businesses that serve our community. Summit Propane notified the HOA 2 weeks later that they would not be offering a long-term contract and would be ending their month-to-month service in 30 days. The HOA was once again scrambling to find propane service. This time, Brenda Connolly did not call me. Instead, I received a formal notice that the HOA was filing a complaint with the Colorado HOA Regulatory Board, claiming I was engaging in a pattern of harassment and interference with HOA operations. I called Marcus. Can they do this? They can file a complaint with anyone they want. Whether it will go anywhere is another question. The regulatory board mostly handles financial impropriety and violations of HOA law, not interpersonal disputes between homeowners and boards. What should I do? Document everything. Show that they have been harassing you with petty violations in retaliation for the mediation outcome. Show that your contacts with propane companies were legitimate business activities, not harassment. The regulatory board complaint went nowhere, as Marcus predicted. But the situation was spiraling out of control. The HOA could not secure consistent propane service. I was under constant scrutiny for trivial violations, and the entire community was suffering from the ongoing conflict. Then Brenda Connolly made a critical mistake. She sent an email to all homeowners explaining the propane supply situation. In the email, she blamed me for the ongoing problems, claiming I was intentionally sabotaging community services in retaliation for legitimate HOA enforcement. She encouraged homeowners to report any suspicious activity involving me. The email included detailed information about my address, my truck, and my business. It was clearly intended to encourage harassment. Within days, I started receiving threatening messages. Someone spray-painted "Traitor" on my driveway. My truck tires were slashed. Someone threw a brick through my front window with a note attached. "Leave our community alone." I filed police reports for all of it. The Boulder County Sheriff's Office sent deputies to investigate. They took reports, but said without witnesses or surveillance footage, there was not much they could do. I installed security cameras around my property. 2 nights later, the cameras caught a figure approaching my house around 2 a.m. The person was wearing dark clothes and a mask. They poured some kind of liquid on my front door and appeared to be preparing to light it. My cameras triggered a motion alert on my phone. I called 911 immediately and watched on my phone as the person fumbled with a lighter. They managed to ignite the liquid, but it did not catch as well as they expected. Instead of a major fire, there was just a small flame that burned out quickly. Sheriff's deputies arrived within minutes. They caught the person trying to flee through my backyard. After removing the mask, they identified him as Robert Hines, a homeowner from 3 streets over. Robert was arrested for arson and criminal mischief. At the sheriff's office, he apparently claimed he was just trying to scare me because I was ruining the neighborhood. The deputies made it clear that attempting to set someone's house on fire was not a legitimate response to HOA disputes. The arrest made local news. Boulder County HOA dispute leads to arson arrest. The article detailed the ongoing conflict between me and the Meadowbrook Village HOA, including Brenda Connolly's email encouraging homeowners to take action against me. The news coverage changed everything. Suddenly, people outside the immediate community were paying attention. The story was picked up by Denver media outlets. HOA abuse was a hot topic in Colorado, and this was a dramatic example of how conflicts could escalate. A reporter from the Denver Post called me for an interview. I agreed and spent an hour explaining the entire situation, from the propane tank dispute to the heating system interference to the harassment and arson attempt. The reporter also interviewed Brenda Connolly, who insisted I was a problem homeowner who refused to follow reasonable rules. The article ran on the front page of the local section. HOA president's crusade against homeowner leads to arson. It was not a flattering portrait of Brenda Connolly or the Meadowbrook Village HOA board. 2 days after the article ran, I received a call from Patricia Fuentes. "Zachary, I want you to know that I have called an emergency board meeting for tonight. I am going to move to remove Brenda as board president and to formally apologize to you on behalf of the HOA for the harassment you have endured." "Thank you, Patricia. I appreciate that. What happened to you should never happen to any homeowner. Brenda allowed her personal vendetta to completely override her fiduciary duty to the community. The arson attempt was the final straw. The board meeting that night was packed. Nearly 100 homeowners attended, many expressing outrage at how the situation had been handled. Patricia presented a motion to remove Brenda Connolly as board president based on conduct unbecoming of an HOA officer, specifically her email encouraging harassment of a homeowner that led to an arson attempt. Dale Morrison seconded the motion immediately. The vote was 4-1, with only Brenda voting against her own removal. Brenda stood up, face red with fury and humiliation. "You are making a huge mistake. This community needs strong leadership, not people who cave to troublemakers. You will regret this." She stormed out of the meeting. Patricia was elected as the new board president by unanimous vote of the remaining members. Patricia's first action as president was to issue a formal apology to me on behalf of the HOA. She also announced that the board would be reviewing all covenant enforcement procedures to ensure fair and consistent application going forward. The propane situation was resolved quickly. Patricia reached out to Mountain View Propane directly and negotiated a new contract at fair rates. Tom Brennan, to his credit, was professional about the whole thing and agreed to resume service. Robert Hines, the homeowner who attempted to set my house on fire, pleaded guilty to attempted arson and criminal mischief. He was sentenced to 2 years probation, mandatory counseling, and was ordered to pay restitution for the damage to my property. He also faced a lawsuit from his own insurance company, as homeowners' insurance does not cover damages resulting from criminal acts. Brenda Connolly faced legal consequences as well. Her email encouraging harassment of me was considered by investigators to be a contributing factor to the arson attempt. The district attorney reviewed the case and determined that, while her email did not rise to the level of criminal incitement, it showed extremely poor judgment and potential civil liability. I filed a civil lawsuit against Brenda Connolly, personally, for defamation and intentional infliction of emotional distress based on her email and her campaign of harassment against me. The lawsuit also named the HOA as a defendant, but Patricia worked with me and my attorney to reach a settlement quickly. The HOA agreed to pay $50,000 to compensate me for the harassment, stress, and property damage I had endured. Brenda Connolly personally agreed to pay an additional $20,000 and to resign from the HOA board entirely. She also signed an agreement prohibiting her from running for the board or serving in any HOA leadership capacity for 5 years. More importantly, the settlement included a complete revision of the HOA's covenant enforcement procedures. The new procedures required clear documentation of violations, fair notice and opportunity to respond, consistency in enforcement across all homeowners, and prohibition of retaliatory enforcement. Any homeowner who believed they were being treated unfairly could request an independent review by a neutral third party before fines were imposed. The story had a significant impact beyond just Meadowbrook Village. Colorado state legislators introduced a bill to reform HOA governance across the state. The proposed law would require HOA boards to follow clear due process procedures, limit fine amounts, provide better dispute resolution mechanisms, and create actual oversight for HOA boards that abuse their authority. I testified at a state legislative hearing about my experience. I explained how a simple propane tank installation had turned into a nightmare because an HOA board president decided to abuse her authority for personal reasons. I described the thousands of dollars in fines, the harassment, and ultimately the arson attempt that resulted from unchecked HOA power. The bill passed both chambers of the Colorado legislature and was signed into law by the governor in May. It was not a perfect law, but it provided real protections for homeowners dealing with abusive HOA boards. My life slowly returned to normal. The propane tank remained in my backyard, fully approved and properly installed. My backup generator worked perfectly during a power outage the following winter. I continued my contracting business and actually gained several new clients who had read about my situation and respected how I had stood up to unjust treatment. Patricia Fuentes turned out to be an excellent HOA president. She focused on actual community improvement projects rather than petty enforcement of arbitrary rules. The community center was well maintained, landscaping improved, and homeowners generally felt their dues were being used appropriately. I even developed a friendly relationship with Patricia. She invited me to join the Architectural Review Committee, and I accepted. My experience gave me a good perspective on balancing legitimate community standards with homeowner rights. We approved several modifications that the previous board would have rejected, including solar panels, garden sheds, and yes, propane tanks. Brenda Connolly moved out of Meadowbrook Village about 6 months after her resignation. I heard through the neighborhood grapevine that she and her husband relocated to a community in Fort Collins. I felt a little sorry for whatever HOA had to deal with her there, but mostly, I just felt relief that she was gone. The whole experience taught me important lessons about standing up for yourself when dealing with unjust authority, but also about the importance of community and working together to solve problems. My initial response to the propane tank dispute, cutting off heat to the community center, was aggressive and arguably wrong. It hurt innocent people who had nothing to do with the board's decision, but it was also effective. It forced a confrontation that needed to happen and ultimately led to real change. Sometimes being nice and following procedures is not enough when dealing with people who abuse power. Sometimes you need to hit back hard enough that they cannot ignore you. I still live in Meadowbrook Village. My propane tank still sits in my backyard, barely visible behind my fence. Every time I look at it, I remember the months of stress, the legal battles, the harassment, and the feeling of powerlessness when facing an HOA board that seemed determined to destroy me for no legitimate reason. But I also remember winning. I remember Brenda Connolly's face when the board voted to remove her. I remember Patricia Fuentes apologizing on behalf of the HOA. I remember testifying before the Colorado legislature and knowing that my experience was helping protect other homeowners from similar abuse. The propane tank cost me about $8,000 to install. By the time everything was over, between attorney fees, property damage, lost work time, and stress, the total cost was probably closer to $70,000. But I got most of that back through the settlement, and more importantly, I got justice. Would I do it again? Honestly, I do not know. The whole thing nearly broke me financially and emotionally. There were nights I lay awake wondering if I should just remove the tank and give up. The stress affected my work, my health, and my relationships, but I am glad I fought. Because if I had not, Brenda Connolly would still be HOA president, still abusing her authority, still making life miserable for anyone who dared question her decisions. And the next homeowner who wanted to install something perfectly reasonable would face the same nightmare I did. Sometimes the right thing to do is also the hardest thing to do. Standing up to bullies, whether they are individuals or institutions, takes courage and determination. It takes a willingness to suffer short-term pain for long-term justice. My propane tank is more than just a metal container of fuel. It is a symbol of the right to use my own property as I see fit, within reasonable limits. It is a symbol of resistance against arbitrary authority. And it is a reminder that ordinary people can fight back against systems designed to crush them, and sometimes, with enough persistence and luck, they can win. The community center has propane heat again. My house has backup power. The HOA board follows fair procedures. Robert Hines is on probation, and hopefully learned that arson is not an appropriate response to neighborhood disputes. Brenda Connolly is someone else's problem now, and I still live in my house, with my propane tank in Meadowbrook Village, Boulder, Colorado. The place I chose to call home, the place I fought to stay in, the place where I learned that home ownership means more than just paying a mortgage. It means standing up for your rights, protecting your property, and refusing to let anyone, not even an HOA board, take away what is rightfully yours. The propane tank sits quietly in my backyard, a beige metal cylinder that caused so much trouble and ultimately changed so much for the better. On cold winter nights, when the power goes out and my generator kicks on, powered by that tank, I feel a deep sense of satisfaction. Not just because I have heat and lights when my neighbors do not, but because that tank represents something important. It represents freedom. It represents justice. And it represents the simple truth that sometimes the only way to deal with people who abuse their power is to cut off their heat and make them feel what it is like to be powerless themselves.